So someone who has been pulled over is being investigated for DUI and then is arrested for DUI. Should that person consent to the blood or breath sample?
In the vast majority of cases, I would say no. Giving a blood or breath sample is going to provide the state with more evidence to prove your guilt. It makes the state's case a lot easier if it's above a point oh 0.08 or there's a high level of a prescription drug or an illegal drug in your system. It makes it easier for the state to prove their case. If you do not give a blood sample, then the state needs to be able to prove that your clearness of mind was affected to the point where you could not safely operate that vehicle. And especially in cases where you're pulled over for speeding or a tag light being out, something that does not prove poor driving behavior, it makes it our case as defense attorneys a lot easier without that blood sample, especially because there is also DUI per se, where if your blood is above a point oh 0.08 and the jury agrees that that sample was reliable, they don't even have to prove that your clearness of mind was affected. They can just say, well, your blood was above a point oh 0.08, that is per se DUI, which leads to a common misconception, I believe, with the implied consent law, in that officers are going to read you, if you're being arrested for DUI, the implied consent law, advising you that you're going to lose your license or may lose your license if you refuse to give a blood sample. Is that true? If someone refuses to give a blood sample, do they automatically lose their license?
No, so it's not automatic. The case actually still has to go through the court system, and the state one is still required to show that there was enough probable cause to get to that point for them to be reading the implied consent law. But even then, when you go into court, the state, even in court, still has to show that one, there was probable cause to believe that the person was DUI at the time the implied consent form was read, but also that that person willingly refused that blood or breath sample. So no, while a common misconception that you lose your license automatically, your license is still valid while that case is pending, which obviously could be months and months, potentially even years.
Yeah, and that's the important part, is you may never lose your license even if you refuse to give a blood sample. You're just giving the state more evidence to prove the DUI, which has mandatory jail time, probation, and the loss of license. So it's better to just not give a blood sample.